There's a recent 10th District case called Camp, and I'm going to call this the Camp case, and I'm going to call the interpretation of the Camp rule. So, in essence, the injured worker Camp had suffered a bad hernia. That's his injury involved a bad hernia. Was allowed for that. He had treatment for the hernia, and eventually, after months or years had passed, his doctor had released him to light duty, and then also said, hey, in addition to being released to light duty, you would be a good candidate to participate in vocational rehabilitation. Sometime after that, the BWC or the employer had an examination done undertaken of Camp, and he was found to have reached max medical improvement for the allowed physical condition in his claims. Later on, he had filed for a site condition, and the site condition was allowed by the Industrial Commission. And then what he ended up doing is he had filed for temporary total disability for the newly allowed site condition. In leading up to the allowance of the site condition, but after he was found to have reached max medical improvement by the Industrial Commission, he had requested, he was being treated for the site condition. And then, so what ended up happening is the staff hearing officer at the Industrial Commission had said, when he applied for temporary total disability for the newly allowed site condition, because his doctors had filled out Medco 14 saying, hey, he would have been temporarily and totally disabled because of the site condition, the staff hearing officer said, well, he didn't try to return to work or try to participate in vocational rehabilitation after he had been found to have reached maximum medical improvement for the physical conditions. And remember, he had not been certified, nor was there a site condition that was present at that time. And so between the time that he was found MMI to the date the site condition was eventually allowed was roughly more than a year and a half. And so this individual Camp, they appealed to the 10th District, and the 10th District, relying upon the decision in AutoZone, stated that notwithstanding the fact that he had this allowed site condition and he was treating for this allowed site condition and he was suffering from this allowed site condition, he did not attempt to return to work, or he did not attempt vocational rehabilitation. And therefore, notwithstanding these other things, he's not entitled to temporary total disability compensation. So what's important for you, the injured worker, is really what the Ohio Supreme Court is saying in this AutoZone case, which is impacting these other cases like Camp, etc., is that you really must return or attempt to return to work, or at least try to attempt to do vocational rehabilitation. That's really the drive of what the Ohio Supreme Court is stating through these again, the AutoZone case. And remember, the AutoZone case basically stated it was an interpretation of Ohio Revised Code 412356F, which involved three sentences. And the first sentence was, if you're suffering a wage loss for reasons directly related to the allowed conditions or your injury in the allowed claim, then you're entitled to basically temporary total disability compensation. And then the second sentence said, if you are suffering a wage loss and or not working as a result of reasons directly unrelated to the allowed workers' comp injury, then you're not entitled to temporary total disability compensation. And so the Ohio Supreme Court basically took the second sentence as the primary sentence, the sentence with supremacy. And again, similar to, and this is kind of how this plays out. You see this play out with this Camp case, and that's how that AutoZone case, the Supreme Court case, impacts the lower 10th District case. Because remember, it's the Court of Common Pleas and the Industrial Commission, and then you have the 10th District, or if it's an appeal from a Court of Common Pleas case, you have the district wherever that county was in. And then the final arbiter for the state of Ohio issues is the Ohio Supreme Court. So the Ohio Supreme Court, whatever they say is law. They interpret law. The laws that they make are what you follow. So that's what happened here. And what's kind of different in the past, what would have happened in the past if this were before AutoZone is, even if that individual, and when he was MMI for the physical conditions, he would not. MMI means you're not getting comp. If you reach maximum medical improvement, you're not getting comp for those physical conditions. So in the past, what might have happened is there might have been months, maybe a year or whatever, where this individual's not receiving anything, and then he gets a psych condition, which was baking in the background. It gets allowed. He had been treating for the psych condition, for a period of time, and so the date that he first started treating for the psych condition, up to the date of the hearing granting comp for the psych condition to continue, he or she would have received compensation from the date he was, most of the time, the date he's first diagnosed and or certified by the psychologist or whoever's certifying for the psych condition. But now, what with this 10th District Camp case is saying is, even if you're treating and all these things, if you're found MMI for the physical and you've not yet been found MMI for the psych, then you really, really, really need to make an effort to return to work, or try vocational rehabilitation. And there's other forms of comp. Let's say you try to return to work and it's not working out. You could apply for what's called non-working wage loss, and you should ask your attorney about that. As long as you have restrictions, you may be entitled for it. You need physical restrictions or restrictions related to your psych condition, and then you have to register with the Ohio Department of Jobs and Family Services, and then each week you have to apply to, I want to say 8 different employers each week, and they have to be good faith applications. And then when you do that, you'll get what's called non-working wage loss. But and the impetus or the reason for non-working wage loss is it's really, again, the state of Ohio wants you to try to return to work, if at all possible. So the reality though is some people, their injury is such that they are not capable of returning back to work, because of the nature of the injury. Well, then those people perhaps would file for a permanent total disability. But nevertheless, if you're not permanently and totally disabled and you've reached MMI, or it looks like you're about to reach maximum medical improvement for your physical conditions, again, I think it's a really smart thing to return to work or attempt to return to work. So you've been listening to Kip from Alec Malik. At the end of every one of these videos, I always recommend that you hire a workers' comp attorney, because workers' comp in Ohio is incredibly complicated, and there's a lot of ins and outs, twists and turns, and you're going to need a workers' comp attorney to help you navigate those ins and outs and twists and turns. So ask your friends, families, neighbors, doctors, co-workers, priest, rabbi, imam, etc. Say, hey, who do you recommend as a workers' comp attorney? Otherwise, search on Google and read the reviews and choose somebody. And if you need to, interview a bunch of workers' comp attorneys, find the one that you vibe the most with, but get somebody involved. I really strongly recommend you do so. So anyways, please stay safe, and I wish you the best of luck with your future endeavors.